everybody. This is the Honorable Sergeant Luca Soliano, and every week I'm going to be answering medieval legal questions from here at my desk. I've solicited these questions from Facebook friends, and I am soliciting more, so if you have a way to get in contact with me, that is a good way to ask me some medieval legal questions, which is a good segue into my reminder that these are medieval legal answers to medieval legal questions. They are not modern answers. They should not be modern questions, and it is absolutely, positively not modern legal advice. Let's get started with the questions. First up, we have Matt Blazek with a question about 14th century heraldry. What exactly can I get away with wearing the livery that identifies me in the service of John of Gaunt? Well, Matt, unfortunately, your question is going to be a little bit complicated by the fact that I'm not 100% sure that you are quite asking what you think that you are asking. Livery, when we talk about this, is items in whether it be by design or color that are given to you by your master in order to show your association with him. And by the nature of that basic contract, anything that your lord gives you in order to represent him is a legitimate form of livery. As a soldier of his, you would probably not be creating any livery that he was not giving you. Therefore, the permission is inherent in the gift and its use. For instance, there may be several forms of livery. If Lord Gaunt gives you his signet ring to carry, first of all, you have been trusted and honored, but also it is appropriate then for you to act as if you, legally speaking, are John of Gaunt. That's what it means to hold a signet ring in trust. In a similar vein, that's what it means to wear his livery. You are lawfully acting on his behalf. If he were to give you his personal surcoat, resplendent in his arms, that would be just as legitimate as if he gave you a simple coat with his color. Now, if you look at the gentleman behind me, who is Sienese rather than English, of course, but you'll note that he is wearing lozengey livery, as we would describe it in reenactment, more so than a heraldic coat of arms or anything like that. And let me tell you, this gentleman is the lord in question. So some of what we think of as a divide between livery and heraldry is a little bit more of a post-14th century, if not post-period, way of looking at that. But in order for me to give you and the rest of the viewers a better idea of how English courts work, I'm going to assume you asked me a slightly different question, which is, what would happen to me if I were to use John of Gaunt's heraldry or livery fraudulently? Or what would happen if I, in pursuit of my duties towards John of Gaunt, messed up terribly? In the English system, in this period, we are looking at three different fundamental types of courts. We are looking at the coram rege, before the king, which is later called the King's Bench. We're looking at the Exchequer of Pleas, simply called later the Court of the Exchequer. And we are looking at the Common Bench, which is, by the end of the 14th century, just as now, where you get most of the cases out of. The King's Bench held very high matters. The Exchequer of Pleas is literally a tax court. We're talking mostly here about the Common Bench. The common bench would not have heard word one about your issues with your master. For one thing, the price of getting into that court would not have been worth it for either party. It's just not where you go to settle that sort of complaint. In fact, they probably wouldn't even have heard it. The only writ, which is the form that you use to get into court, what we would now call a complaint, is very restricted in this period. The only one that at all applies is called a writ of trespass. And this is a brand new method of action that becomes popular at the 14th century. At the beginning, it's only actions that have breached the king's peace and were done with force and arms. However, by the end of the 14th century, this has been expanded to gentlemen who have trespassed in other capacities. And this is a very, very wide definition of trespass to include actions that we would now call malpractice. So here are a few actual instances of this case being used. A blacksmith who drove a nail into a horse's foot rather than the hoof. It could not work. It was lame, and so there were damages created and damages awarded. A surgeon tried to fix a woman's hand and made it worse. This caused damages. These damages were assessed by a court. In both of these cases, these are people who have been hired with money to perform a service and who failed in that service. This is not you as a soldier of John of Gaunt. As soldier of John of Gaunt, you are in service to him and he is your master. Therefore, the only appropriate court that this might ever have seen would have been John of Gaunt's local court. Now, local is not a word that was used contemporaneously, but this is how these courts are described. John of Gaunt himself would be your judge and would have the power to take most actions against you. Now, by the end of the 14th century, these were overseen by the king's courts. However, if you messed up, you were using his livery while doing it, and he decided that that was pretty much the end of your days, the King of England is probably not getting involved to save you. I hope that this has provided a general outlook of your legal lack of options as a soldier in the 14th century. For additional reading, I suggest What Happened in the English Legal System in the 14th Century, and Why Would Anyone Want to Know by Charles Donahue Jr. Our next two questions are going to be addressed together as they both relate to relatively early medieval Irish law. These questions come from Cope as well as Sir Gelock. Cope says that she's always been interested in how the value of people is calculated. She knows correctly that Irish law has some formal price points for the death of a person and wants to know a little bit more about how those work. So, Cope, you are absolutely correct. Irish law has some set in reasonably permeable stone ideas of what a man's value is in recompense. This is a term that is generally called weregeld, and that is a term that has arrived to us out of an amalgamation of a lot of the more Germanic constructs of law in this period. It is, by contrast, not a concept that you see directly in Roman law, or the law that was more likely to be found the further south that you go in Europe. That type of law is more likely to assess damages in a different way. So, in Ireland, in the early medieval period, we need to understand that even within different clans, tribes, however you want to categorize them in this period, you are looking at units that the Irish called Derbfin, or true kin. I'm going to say right now, I don't speak Irish in the slightest. I'm doing my honest level best. You're going to get what you're going to get. In any case, your true kin are the descendants of the same great-grandfather. So when a man is harmed or a woman is harmed, the recompense is paid either directly to him or her, or if that is not possible, to their true kin, the descendants of that same great-grandfather. Now, there are 3 types of people in Ireland at this point. There's the Nebend, which is generally translated as the sacred or holy. These are your lords. These are your clergy in a lot of cases. And unique to Ireland, these are also your bards. We're going to leave that one be for a minute. The next class below it are freemen, the sor, and below them is the dor, or base people. These generally, in a general medieval construct, refer to free and less than free tenants of land. So, what does this mean for your weregeld? Well, Irish law establishes a bunch of rules for when weregeld must be paid, the simplest of which is you have killed a man unlawfully. You then must pay his weregeld to his Derbfin, his true kin, and this is compiled in 2 ways. One, you start with his 7 cumals as his eric, or his body fine. This is the worth of a man, period. Whether he be base, free, or holy, a man is of a certain value, and that value is 7. That's what it is. On top of that, you must pay his honor price. This is the price of the man's honor that you have degraded by killing him. And so in order to make his true kin whole, you must repay both his honor price and his body price. The body price, for instance, of a boer, which is a type of freeman, is 5 sets. At the end of the day, we're talking about 2 to 3 cows here. So in terms of Irish law, killing people unlawfully can get really expensive really fast. And that is not when we're talking about lords here. So this is a very strong, very immediate recompense way of preventing the blood feud. Which is another idea that happens all over the world constantly, but was an especial problem that they worried about in these communities at the time. And the idea of a weregeld, an immediate payment that stops the violence, was a very attractive idea in Ireland, in Iceland, in Norway, in much of what's now Germany, and to a lesser extent was also used in places like Italy. Geelach has asked a similar question-ish about Irish law. He has asked several questions about bees. Now, it's important to note that bees take a very special place in Irish law, and it's a different place than they find themselves in other countries in this period. Bees are animals. You would think of them as an animal or an insect or whatever, as would I. In Ireland, in this period, they are considered to be more or less the same as any other piece of agricultural technology. So, if a neighbor's bee stings you, it is essentially considered the same as if you have been injured by his plow or his horse or his slave. And therefore, his body fine, of course, a partial body fine, could theoretically be invoked. Instead of that, which is a little much for a bee sting, we have a special law. This is called the Beckbretha, which literally means bee judgments or bee laws. So, if someone's bee stings you, you are entitled to a meal of honey from, presumably, that hive. There are some indications, and some people believe that that actually means a portion of mead. I don't know. That seems really unclear what that means in this context. This is not a bad deal, even if it's not mead, however, because honey is not cheap. Now, if you die because you have been attacked by these bees, which, by the way, happens on occasion, your Derpfin, your kin, get 2 hives. 2 hives is a lot, especially in a society that doesn't really have modern collection and swarming techniques, for moving hives the way we do now. But it is also a pittance compared to what you would theoretically be owed if you were actually to be killed in an at-fault weregild situation. Finally, if your bees are seen on a neighbor's farm stealing, then you owe them the next swarm. It's a little more complicated than that. That's the gist. That, to my mind, suggests the authorities of Ireland saying, guys, this is not really a problem. But if you're going to steal the pollen, what have you, from the neighbor's farm, give them the next swarm. Again, we're looking at a system designed to prevent the feud. And if you look at it in these contexts, it becomes very obvious and reasonable and really, I think, cool little pocket of medieval law. So thanks for that question, guys. Next up, we have Marcus Pinarius Draconarius, whose extremely detailed legal question I'm simply going to read verbatim. As a legionnaire of Rome during the reign of Marcus Aurelius, if I'm stationed in Western Gaul but owe money to a lender in Rome, and I have defaulted on the debt, may the lender initiate an action in Rome, or must he travel to where I'm stationed and file with the local magistrate? If successful, how does he collect his judgment against me? So, let's start breaking down this question. First of all, this is a really wonderful question because it gives me all of the pieces that I need to really give a full answer. It gives the class and time period of the person having the legal issue. It gives the location of it. And it's detailed in what the question is. So thank you, Marcus. To get to your answer, we are going to have to clear up a few of the terms between modern terms and their Roman equivalent. Marcus describes himself here as a legionnaire of Rome. So, first of all, that's good to know that he's describing a legionnaire, because a legionnaire is considered the legal property of his centurion, or to use a modern term for it, his chain of command, kind of as a whole. A legionnaire of Rome is not a wrong way to describe it, but it's also perhaps not the most contemporary Roman way to conceptualize where you fit. Because a Roman legionary at the time would have probably said, I am of the 13th Legion. I am of the century of Gaius Publius Maximus Cicero Naso Scaevola. And the reason that's important is because that centurion, that governor, that senator playing general for a day is your legal master. You are in functionally one of the forms of Roman slavery for the duration of your contract. One of the things that does is that can and really does resolve you of the potential to have judgments, or at least civil judgments, performed against you during your time of service. That said, there were other ways of collecting those judgments. There were other ways of collecting those judgments against your family. And many legionaries did find themselves in serious debt for a variety of reasons. So, what happens when you, Marcus, have found yourself in debt? First of all, no one is coming to make you a slave immediately. And, depending on where you are in Roman history, outright debt slavery, or nexum, may or may not have been abolished. It seems during the reign of Marcus Aurelius that it was still in practice. You need not necessarily travel back to Rome to have that court case. The reason for that is twofold. One, you would be informed by letter, and we know this because we know that many reportings on various court cases traveled to Vinolanda and other places along Hadrian's Wall in Britain. And we also know that we have evidence of court cases in Rome where the parties were not necessarily present because we knew them to be on campaign at the time. In those cases, they may have an advocate, they would have family members, etc., in place for them. Now, if a person had no family, was a legionary, all of that, they're probably not getting a loan to begin with. However, in lieu of all other options, in lieu of any ability to pay back the debt, you have two final options. One is a plea to the Senate, or to resolve all debts. This is less unlikely than you might think, and happens several times during Roman history, pretty much as a way to buy stability. Jubilee resolution of debts is something that extends through the medieval period. Alternatively, you could ask the debt to be taken on by one of your commanders, by the governor, etc. Again, this is not outside the realm of possibility. It would depend on your conduct and a number of other factors, like your ability to take on that loan. Finally, once you were removed or excused from service, which may come about sooner if your governor doesn't like you and you owe money, you may end up a bonded slave. Now, when we talk about slavery in this instance, there was chattel slavery in Rome. This is not that. This is closer to indentured servitude. This is not I'm not getting into the moral issues of the various types of slavery, but I am going to point out this is a separate legal construct. Our final question comes from Rowan. Here's an interesting one. If I, a 14th century Welsh merchant's daughter, married a 14th century Turkish horseman who is Muslim, would I be required to change my name, and if so, how much? Well, first of all, Rowan, the first thing I have to say is that there is no court in either the Islamic world or in Christendom at this point that would have any authority or desire to require you to change your name. However, there would be societal pressure to, of course, identify as the wife of your husband, just as there would be now. And this is an opportunity to talk more about how names as a societal construct differ in this period than they do now. Modernly, we have a very strong idea that we own our names. I am Luca. I am of the Soliani. And if I want to change my name, or if I feel I should change my name, then I am the sole person who has the right to change my name because it is something that I own. This is a modern concept. I also consider it to be a good concept, but it is a modern concept. You do not own your name in the same way in our period of study in at least most of the places that we study. Your name is how other people describe you. Now, it may be certainly solemnized, it may be in records, but it's going to be in different forms. And most importantly, it very well may change over your life. If you happen to be named Mary, for instance, or John, you're going to have a nickname that goes with your name. You don't get to choose that. You don't get to change that. So if you are Rowan Ustad's wife, then you are Rowan Ustad's wife. And what your feelings are, frankly, about your name is not particularly important. There's no place to change it. There's no place that's going to record a change in it, but people are going to start calling you Rowan, who is Ustad's wife, or, to be honest, probably just Ustad's wife. This is the historical nature of our period. So when you ask, would I be required to change my name, and if so, how much, you would still be Rowan. You would still be Mary. But in terms of how other people describe you, to give the medieval answer, that's none of your business. You don't own that. They own how they describe you. You don't own how they describe you. And here's Rowan's second question and our last question for the week. If I, a 14th century Welsh merchant's daughter, ran away, important distinction, and married a 14th century Muslim Turkish horseman without my father's consent, am I actually married? Does he still get my dowry? And if caught, what are the consequences? Well, a little bit like your former question, there is no law that would put you in front of a court or a magistrate and injure you in any way because you have done the things that you have listed. This is not a matter for a court. A little bit in the same legal principle as our earlier heraldry question, you would be answerable in this matter to your master. Your master, as an unmarried woman, is your father. Your father could legally imprison you, beat you, and potentially kill you. It is worthwhile to note that while the legal concept that these things are permissible is monstrous, it didn't actually happen very often. In reality, fathers love their daughters. And so, while that may have been legal, we should also talk about what was more common. So, if you ran away, does he still get my dowry? I don't know. Did you steal your dowry? If not, the dowry is coming from your father. So if you have run away to marry without his permission, your Turkish horseman is going to sadly be without dowry. If caught, what are the consequences? Well, frankly, their chances are you're going to be more or less locked in your room until you are married appropriately. And you're not going to have the complete ability to leave your new husband's lands or ship or what have you until that new husband and his family are very sure that you're not going to want to. And that is the unfortunate reality of that situation. Now, are you actually married? Well, marriage is not a religious construct in this period, really, either in the part of the Islamic world that you're talking about, and certainly not in Wales. It is a property contract, in which case one is married, Latin meaning to be provided, with a wife. And so, are you actually married? If you marry that person and you are married together and it passes the duck test, it quacks like a duck, it quacks like a marriage, then you're married. That is how it works throughout Christendom and the Islamic world in this period for a variety of reasons. The movement of the act of marriage to be a religious act, or a primarily religious act in period, is actually a Protestant idea. It is adapted by the Catholic Church as part of the Counter-Reformation, but it is not a concept that you would have been particularly would have been present in the 14th century. So, to reiterate, if I, a 14th century Welsh merchant's daughter, ran away, good luck making it to Turkey, that would be quite a voyage, married a 14th century Muslim Turkish horseman without my father's consent, am I actually married? Yeah. Does he still get my dowry? Only if you stole it and given it to him, at which case I'm not sure it quite qualifies as a dowry, but that's a question of linguistics, not law. And if caught, what are the consequences? Well, assuming that his family approves, assuming you're going to live with him, and assuming that you're going to convert, there aren't consequences from his family. You're probably never going to see your family again, but again, these aren't legal consequences. These are the social consequences of running away, converting to Islam, marrying a guy your parents don't like who is below your station. And that's the situation that you're looking at. Folks, I hope this has been helpful. If people continue to ask me questions, I will continue to help to hopefully provide answers, and I will continue to hope that they are good. Thanks for watching, everybody.